Hi, thank you all, audience members and speakers. It's been an incredible day of conversation. More than just conversation, though, we have really succeeded in bringing lessons learned from across the country in the dialogues, lessons on best practices and on strategy, here to DC, where policymakers, lawmakers, and advocates work to make the change at the policy level that will, we hope, make a real difference to people on the ground. Changes that will bring policy into line with best practices, basic due process, and human rights standards, and in many cases, save taxpayer dollars. We look to the successes and best practices in the criminal justice system and correction system not because immigration detention practices should be modeled on the correction system by any means, but because there's no reason for us to be reinventing the wheel. In the spirit of not presuming detention as a default, we started the day with an examination of models for alternatives to detention, looking at existing community-based programs such as those piloted by LIRS, described by Brittany Nystrom, designed to provide individualized assistance to immigrants in removal proceedings, as well as ISAP-2, the formal ICE alternatives program provided by BI. Julie Myers-Wood reported that ISAP-2 costs just $8 per person per day, compared to $164 per person per day for detention, and leads to 96% compliance for final hearings and 84% compliance with removal orders. Tim Murray of the Pretrial Justice Institute noted the, quote, kinship between immigration detention reformers and pretrial services practitioners, and called for nimbleness in our responses to individual cases, not a one-size-fits-all approach to alternatives. Both Tim and Cliff Keenan of DC Pretrial Services and a federal prosecutor for almost 2 decades emphasize that it makes no sense to assume that one person's risk is identical to another's. Validated risk assessment is essential to make appropriate decisions about alternatives. The District of Columbia is able to release 90% of its pretrial population with reasonable compliance rates and rearrest rates in the single digits. Positive results similar to those we heard in our dialogues across the country, from programs implemented in New Orleans, Houston, Santa Clara County. Pretrial services administrators have developed expertise over decades that work for a diverse range of populations and the metrics to evaluate their effectiveness. Brittany and Julie both echoed the need for metrics to evaluate and improve alternatives to immigration detention. And Julie, who ran ICE under President Bush, posed a challenge. Can we find better ways to get compliance without detention? This theme was repeated throughout the day. And I know most of us in the room would like to see the administration and Congress take it on. And to that end, I want to highlight the importance of the congressional bed mandate as we talk about detention reform. As a few of our speakers noted, including Gary Mead, head of enforcement and removal operations at ICE, the agency and some members of Congress interpret DHS appropriations language to mandate the agency to maintain and fill 34,000 beds on a daily basis. It precludes ICE officers from making decisions about detention based on the agency's priorities, policies, and need. Instead, in carrying out their professional responsibilities, they're faced with a number that effectively serves as a quota. The mandate also makes it impossible for ICE to actually create cost savings for taxpayers through more effective and appropriate use of alternatives to detention and alternative forms of detention. Julie flagged in her recommendations for immigration reform that ICE should have flexibility to make individualized determinations about detention. This bed mandate approach was flagged by several speakers, including Wade Henderson and Brittany Nystrom, and I will add myself to the list of people who find it problematic. We heard some strong calls for improved access to counsel from the lunchtime speakers. Wade Henderson noted the, quote, failure to execute the letter and spirit of Gideon v. Wainwright, even at its 50th anniversary, for both detained and non-detained immigrants. Julie Myers-Wood recommended that immigration reform look at a broader right to counsel for immigrants in removal proceedings. And Dr. Richard Land of the Southern Baptist Convention called counsel a, quote, basic right, and proposed a domestic legal corps to support legal education for people who will commit to pro bono work after graduation. The speakers in our final panel on counsel made clear the need for expanded LOP, easier access for attorneys to their detained clients, citing of detention facilities actually near to more than 1 or 5 immigration attorneys. Shout out to Ken and Jonathan. And government-appointed attorneys for children, people with mental disabilities, and other vulnerable populations. Legal information and counsel increase justice and also increase court efficiency. As Jonathan Ryan said after his kind of fantastic story, we need to decrease obstacles and increase incentives. We were fortunate to hear from 3 consummate experts with incredible perspective on the immigration detention system. We heard a few basic points. First, civil immigration detainees are not being held for the purpose of punishment. Second, it's difficult for jails to provide civil conditions or even comply with the most recent PBNDS, a point that Steve J. Martin, former general counsel of the Texas prison system, also made at our dialogue in Austin. And third, effective oversight and accountability is essential, particularly with multiple sets of standards, private contractors, a new PREA rule coming down the pike, and heightened attention to the use of segregation in immigration detention. It was good to hear that ICE is still working to improve conditions of detention, including contact visitation and up to 4 hours of outdoor rec. Dr. Dora Schreiro flagged the need to continue to look at the types of conditions that are appropriate for civil immigration detention. Along with the bed mandate, mandatory detention is the not-so-secret elephant in the room driving detention levels. Gary Mead reported that 96% of detained individuals are subject to mandatory detention or an unspecified criminal conviction. At lunch, Wade Henderson said that restoring the discretion of immigration judges is the single biggest thing you can do. Without an individualized assessment of the need to detain and court review of custody decisions, detention is arbitrary according to human rights standards and also contrary to a basic sense of fairness. Hope and Naz Muskatim and Abdoulaye Ba, both impacted by mandatory detention laws themselves, generously shared some of their own stories to help those of us with the good fortune not to have been swept up in immigration detention to understand the challenges that this system can create for real people. It's not working the way it is right now, said Abdoulaye, echoing, remarkably, the words of Secretary Napolitano, who said in 2009, "The paradigm is wrong." But there is definitely plenty of reason for hope. First, over the past 3 years, ICE has invested significant resources and time in making essential improvements to the detention system, adding on-site monitors, creating a detention hotline, an online detainee locator, most recently rolling out an automated risk assessment tool. Even more, though, we are building new alliances through the dialogues and plenty of other incredible work by you all and others across the country with law enforcement, corrections professionals, criminal justice reformers, the private bar, and yes, conservative leaders like Grover Norquist. This morning, Mr. Norquist described the reduction in prison populations in states like Texas and the increased use of alternatives throughout the criminal justice system as examples to inspire change in immigration detention practices. He identified the common cause of immigration reform and criminal justice reform advocates, pointing to the Venn diagram overlap of immigration detention. With immigration bills on the horizon, the work keeps moving forward. Thank you so much to Jones Day for hosting us today and to the universities in Texas, California, Arizona, and Louisiana for working with us last fall. Please join us in the foyer for drink and food. Thank you again.